So thank you all for joining today. Today we are going to speak about AI assistants dedicated to trademark professionals. We called it from search to substantive decisions because we will see you can really get help through all the prosecution life cycle with these kind of new systems, new tools that are on the market, and of course we'll speak about ours. So let us just introduce ourselves with Ariana first.
And hello, everyone. Thank you for joining. I'm Mariana Giovannardi. I'm an Italian attorney. I'm also the director of the Italian department of Brandstock. And it will be really interesting, I think, to discuss about this matter with you because on a daily basis, we have to face a lot of questions and issues which may be supported by this tool and also have new ideas.
This is great. So we confront our point of views. On my end, I am more on the SaaS side, so the software side, and of course, working closely with all our experts. So I'm leading this client solution specialist team. It's the team working on doing demos of our solutions to our clients, also trainings, and maybe most of all, working also with the R&D teams, the development teams, to make sure that we adapt our roadmap. So that's a really important point because this is really the expert feedback that then feeds our tools. At least that's our goal. So if not, we miss the point. So yes, for the agenda today in this session, we are going to review from such to substantive decisions, how you get help across the prosecution lifecycle. That's really our number one point. Then we will see the early stage legal analysis where you can get help. That's really the word, help and guidance. That's we will insist a bit loudly on this to perform risk assessment, to conduct lawfulness, registrability checks, to help, of course, detect the inherent distinctiveness of a trademark or the lack of it. And then also how you can get help from assistants to generate drafts. So drafting of goods and services is one thing, but of course also drafting of a reply to an office action and drafting opposition or cancellation submission. Then we wanted to highlight also how we try, at least internally at Questel, to integrate the different tools and to build bridges between those tools. So here speaking mostly about the IPMS, but also on how we want to use also the search tool data Markify. So what's our plan there? So this is the agenda, and happy to have Ariana with us, yes, to comment and give some insights on where the struggles are. Because if no struggle, we don't need these kind of solutions. So to jump in, we are starting with the intelligent assistance across the prosecution lifecycle. And the goal here is to review together at which stages you can get help. It's a bit what we covered already in the agenda, to be honest. So I'm not really diving on it too long. But as said, at creation stage, you can get help on the registrability check part of things, inherent distinctiveness or not, analysis of the linguistic meaning. And we will see some real life examples and some totally fake scenarios where we try to use those skills. In Qtina, our tool, this is what we do. We call it a skill. So the aim is that the SaaS solution is skilled enough to help you on specific use cases. It could be with some AI tools that you also have at creation stage, name generation, for example. But this is not something that we have included, at least at the moment in Qtina. Why? Because it's not the top priority of our users. So that's really the why. It could change. Search stage, so to get risk assessment. At filing stage, and here, we are speaking about trademarks today. So I'm skipping a bit the patent parts, but it is written in the slides. You can, of course, get kind of parallel corresponding features on the patent side. So here we're going to speak about goods and services drafting when they would be speaking about patent drafting. Prosecution, it was what we were citing before, reply to office action, opposition submission or cancellation request. And managing the IP insights on our end, we are not focusing too much for the moment on the analytics because our clients are not focusing on the analytics. But that is also something that may evolve over time. Intro, but important, the human in the loop approach. So what you see here on this slide is a disclaimer that I extracted from the Qthena bot. One of its replies was, hey, disclaimer, this is based on the information provided first. And second, it doesn't mean that you can escape any human legal analysis. So anyway, legally, you are bound to have your point of view. I mean, this is an important part. So be it in your teams in-house, be you a corporate or law firm, or be you using outsourcing this legal review to someone, anyway, someone must come in and check what has been provided by Qthena. We still have many tactics set up in the system that are put in place to have really accurate answers, accurate replies by those large language models, LLMs, that we use in Qthena. What we use, by the way, is Gemini from Google. Currently, it could change over time. This is what we decided to use in our AI assistant because currently it's the best for these goals, not for everything. So this is what we are using, but we are using a private and secure version of it. This means that Google, who is behind Gemini, is not keeping your prompts, is not using your data. This is also why, by the way, we cannot tell our users, yes, the tool will learn from you, because if we were doing so, it would mean that they keep your data, which is not the case. So there are always a good side and a downside of these kind of decisions. The other thing that is good to know is that Qthena will really read every single line that you provide in documents. We will see in the examples, in those examples of reply to office action, etc. You provide some context to the tool, and it replies based on this context, and we force it to read it, which is not at all the same as taking a Gemini or ChatGPT online, even a paid for version. It's we use what we call the context window mode. So we really force the tool to look into everything, to reply. And why do we do that? To try and avoid hallucinations. Because everybody knows now about AI hallucinations, especially so that currently there's been I think, Ariana, a huge activity on lawyers who have been tricked into using fake references.
Absolutely. Well, I remember that the first case we had in Italy was from the court of Rimini on the Riviera, and actually a lawyer was condemned by the judge because he used some case law retrieved via ChatGPT, etc. But in mentioning it, actually it cited, the numbers of the decision and also the text of the decision, so the content of what was interesting for the lawyer. But these decisions were totally fake, so he was sanctioned. And the same happened recently also in the US, in UK. So what's important is that we always need to pay a lot of attention and always keep in mind that what you put inside is what you get. So if you put in the system correct information, clear information, you will get a clearer view and clear information. But we must also always have a critical approach when we obtain some results, especially when we're talking about case law, for example, because the risk of fake information is real, especially because these tools, for example, ChatGPT, etc., are instructed to give you an answer anyways. This is why we suggest, and there's this disclaimer, of course, to always counter check what is the outcome. But on the other side, we've managed into Qthena to try overcoming some of these hallucinations with all the IT solutions that were found on our side. So even though it's a safer place, I would say, than other tools, of course, we always need to provide also with our critical approach and experience.
And you're right, it's also about being critical, because we will see with reply to office action, the tool will provide you with strategies, but the choice of the strategy to apply is up to you, even though, of course, the tool is also there to tell you, well, if you can ask it, what would be the best strategy, and it would answer. But anyway, it would give you a choice of strategies. So yes, that's I think the security, privacy, disclaimer, legal opinion part is the absolutely needed intro before we dive into the examples. Just very quickly also, on at least in our system, it's really not only all about AI and chatbots. That's of course the core of it, but that's not the only part. There's some authorization. It means that the tool is able to find content inside images. This is what we call text content inside images. So it reads images, it can comment. Document review and annotation with the Adobe Reader and more. A word processor translation. This is also because those LLMs, and they are really getting better. And we are prompting we take Gemini, but then our teams pre-prompt it. So they make it IP savvy and they improve it. So that's really, they improve it for your needs. So the translations are really surprisingly good. Collaboration also is in, and search inside your content, search inside your folders, your documents, etc. So yes, AI is key, but it's never only about AI, whatever the discussion. We have a few polls in the session, not a lot, but this is our first one, and we would like to know from you for which of the cited use cases you think that AI helps you most. And here we thought about registrability check, goods and services drafting, reply to office actions. What are the ones in which you would either you are or you would use it more because you think it's maybe where either you have more difficulties? I was not reading the message. The tool was telling me that if I wanted to see it, I need to have less windows open. So the answers are, all in all, goods and services drafting, risk assessment, mainly, reply to office action, registrability check less, but I think it's sometimes underrated. From some meetings, I would say that. And opposition, cancellation, submission is also useful. So it's mainly goods and services drafting, risk assessment, and reply to office action. No big surprise. Opposition, I thought could get a higher score. But thank you for taking the time to answer. And we're gonna now start looking into details and examples because I think you are here for that. So we were citing risk assessment, lawfulness, registrability check, and detecting inherent descriptiveness. So let's start with some risk assessment. Here is just an example in what you can see in the slides of the interface of Qthina first. So on the left, you have the panels. Sorry, I have to look on my second screen. So on the left, you have the panels, and you see it's a project in which I have several sessions. I can name the session, so I can really organize well my Qthina. If I don't want that, I can also use, as some people use, a chatbot and just over time, not reuse, not rename, not keep. But if you need to keep a project and to come back on it, maybe 1 month later, maybe 1 year later, collaborate, share it, you can. And this is what is great. It's really a workspace. In this example, I provided a search report, which was extracted from our search tool, Markify. So there's a search report, and then started asking Qthina to analyze the search report. Of course, we are not here to look into all the details. It is not possible, but just to show that this is the kind of things you can do with Qthina. You can have maybe only 2 trademarks that you want to compare and just provide the details of those 2 trademarks, and that we will see another example like that, or a search report that you provide. If you provide a search report, and exactly as Ariana was saying before, the more accurate you are, the more accurate the answer will be. So we would really advise, sorry, I was looking for the word, advise to maybe filter out a little bit the report before you give it to Qthina. What it will do is not comment each and every result, but it will extract the most tricky results out of it and draft a review, an overall review of the report. And because the chatbot is there, it's open for you. It's your own chatbot. You can start asking questions. And did you find any goods and services that were relating to whatever vegetable, as an example? And it can find into all the languages because there is no problem with languages for the LLMs. You can chat by writing, and you can also use the speech to text. So here it's really for you to have a kind of vision of what Kirina looks like and how you can either provide a document that is the scope, the context in the session, or simply write in the chat and explain what you are willing to do. So this was just introduction to the interface, and it was a fictive scenario of I want to compare Axel with double C to Axel with an X, and if the question was will it be able to compare goods and services and the signs themselves, the answer is yes. That is the goal of the risk assessment, really. Maybe I go to the next one to start discussing with you, Ariana, also. I think this one is a fairly case. This risk assessment example here was the McQueen versus McDonald's. And the tool has analyzed first the image. It's to show that the tool is able to not only find the image, but also analyze its content. So it started describing, it's a direct inversion of one of the most famous trademarks in the world. So risk of refusal would be high. I'm not sure sometimes, I don't know, in this example, for example, I took it because it's a funny one. I'm not sure everybody would think, do I really need this tool to help me? I would say, yeah, depending on the jurisdictions, yes. And also, the goal is to gain time. And Ariana, in writing, your review of what you think about
That's for sure. That's for sure. Actually, maybe this example is a bit extreme, but also because the purpose was of showing the comparison between the signs. But I guess that in cases where the difference, the similarities are not so clear, not so immediate, these asking the tool to do this risk assessment can be helpful. It could give us other ideas to be used when we have to define whether a mark is risky or not. And also, well, in this case, for example, the tool suggests abandon the design, and I think that all the lawyers here would say the same. Not only due to the similarity of the signs, but also the fact that McDonald's could also raise issues connected to the association of cannabis products to food. So there's a matter also of brand reputation apart from the infringement. On the other side, in other cases where we don't have such similar trademark, I think that having a tool giving you some additional ideas, some support can of course give the possibility of gaining some time because it analyzes all the information for us and gets back to us with information that maybe would take time for us to retrieve. And on the other side, it could also give suggestions on strategies we didn't think about. So why not? I mean,
Yeah.
okay.
And also, I think sometimes it's not revolutionary. Sometimes it's not the tool will not, and that's not what we expect. Get out something brand new that you would not have thought of, but you're gaining time in the drafting. So if that is also what is needed, I'm not saying to do copy paste and not read. I'm just saying you're gaining time in the drafting. So it was an example. I also used it for a very good reason. That is to speak a bit about the technical limits of the LLMs, and we referred a bit before to the hallucinations. Why do the LLMs hallucinate when we're not using them seriously as we are doing in a tool like ours? Why? Because they don't read all the data. They have all, let's say, all the internet knowledge, and they just try to extract information out of it. They do sampling. They even if you provide to ChatGPT big file, it will take out only some pieces of it and it will reply based on that. What I mean is that those LLMs are not, or at least as of today, are totally unable to go and search inside the full millions of results of a trademark PTO registries. So this is simply not technically possible for them. This is why it is always a combination with these kind of tools, assistants, on top, and to use after having used your search or watch tools. Be it Questel or not, that's not the problem, but you cannot replace the search or watch tool. And also, that's why when it says something like here, it's written, it's a direct inversion of one of the most famous trademarks in the world. It's not because it's able to search inside those millions of results. It would skip 98% of them. That would be bad. That's not what you want. That's not what our algorithms do. But it's just because it's common general knowledge on the internet. So it's something to take into consideration when it tells you it's famous. It doesn't mean there's a court decision that is well known. It's just really well known, So that was also why I chose this basic example. Funny one. Another, I will skip it maybe a bit quickly, but as another example was Super Mac versus Big Mac. And it says very high risk of refusal, and all opposition strongly advised to consider an alternative mark, then decide. And you know what? Super Mac kept their trademark. And you know why? Because this was in Ireland, and because Big Mac was, McDonald's was unable to prove use of their Big Mac trademark in some of the goods and services. And it was also for fast food. I mean, that's really the same. So all in all, the tool cannot know everything. And this notion of, was McDonald's really using also all the trademark for all the goods that it was willing to cover? That's also a bit outside the system, but a very also good example.
Absolutely. If I may add something, is that, of course, the fact that this tool gets information like the reputation of the mark just because it's known, it doesn't have the access to the decision, it cannot provide evidence on the reputation of this mark. Must be read also in support for a lawyer, because of course, if we are talking about the same kind of goods, I would give it for granted that the reputation refers to food in this case. But if I had to apply for another class, like the example of Super Mac versus Big Mac, maybe I could consider, okay, this Big Mac is famous and reputed for food. I know the system is giving me the suggestion to study an alternative mark, but I have to keep in mind and hear the human approach, which has to be put that maybe I have the chance to overcome the reputation of a trademark by filing it in a completely different class. Of course, it's just giving us the ideas on which we shall think about. So if I received this kind of output, I would, okay, let's check the real situation I'm facing. But this information I think are super useful because, for example, in some fields of business, we may not know that a trademark is so known.
So absolutely. In this example, we know. And also another thing is that you provide context to the system. So if that's about a brand for which you have some survey reports proving the reputation of the trademark or the fact that it's well known, if you have whatever, provide it to Kitina and ask it to take it into account. Take this document into account. So that is really the other side, that we are feeding it also voluntarily. Then we switch to some other examples. The lawfulness registrability check. So yeah, ISO is underrated, we know it, yet we all know there are a lot of mistakes that are done in the choice of trademark names. Sometimes, and I would say most of the time, we discuss it with Ariana, there are people who are not IP savvy, so not those that are here today with us in the webinar, but small entrepreneurs, etc. Okay, they are not IP savvy. They don't know that they should not take the exact name of what they will wish to sell and use it as their brand name. Okay, so trains. They need sometimes to face an issue to understand it. But for all those who are IP savvy, this part is not. So the inherent descriptiveness, okay, maybe they can analyze. What they cannot analyze is the potential meaning of these words in all the languages of the world. Or is there something that could be a geographical indication somewhere in the world? Or there are things that we do not know, and we really need to rely. I'm not saying that stops, but we need to rely a lot on outside counsels for that, whatever, internal or external. So here, this was an example, real life example of the Pajero trademark. I wrote to the system, okay, I want to file Pajero trademark. Okay, I did not even say for which goods. It was a lazy question just to show what kind of reply I could get. And is that acceptable for the US, China, Japan, and Europe? Did these things also with vulgar words to check what it said. And here the tool is answering, okay, Pajero is a very well-known trademark of Mitsubishi. One part, it knows it. We saw already with McDonald's because it's well-known, not because it searches all the trademark registries. Second, very negative vulgar meaning is, I did not know it. I don't think Mitsubishi knew it. So check by yourself. I didn't want to show it in the webinar. You've got a nice beep. But this is really negative. And to be honest, would they have used this kind of tool? Maybe they would have changed. Maybe, not sure. But of course, they are targeting the US. Then, of course, they are targeting Latin America or Spain. So yeah, that's part of it. You can get help in the linguistic analysis of the trademarks that you wish to find. I'm not saying LLMs only are needed. We have tools with linguistic option. I'm saying they go further, really.
Yeah, I think that this kind of assessment would be super helpful, especially because we, of course, know our mother tongue. We work in a different language, but most of the time our foreign language knowledges are limited. I may know some French or Spanish, but I wouldn't have known the meaning of pajero if it wasn't for this example, for example. So
That's it.
we have to assess, especially for clients who are going to start very big filing projects and need to assess the chances of success of a registration at the phase of examination before the offices. Having this kind of information is very useful because we can also suggest to our client to keep this in consideration and maybe change the filing strategy depending on the registrability of the mark in the different offices. So this is an additional support and may also, I think, reduce the expenses that we face when we discuss this matter with local agents. So we do a preliminary check and arrive to the local agents with already an idea. And this
is to try to do the knockout more efficiently, because for sure when you have to dig, as we were saying, you don't escape the more the deeper legal advice. But at least if you right away see there's a big blocker, maybe that's really an important trademark for you. There's a good reason you keep this brand, maybe not, and in this case you skip it right away. So it's a great, I think, gain of time. It was an example. I don't know if I put others there. Drill Monster. This was more here the descriptiveness part. It's a fake trademark for drilling machines. Okay, so the tool analyzes the descriptive part is drill, the fanciful part is monster, all in all together, rather suggestive. And then it answers country by country because I asked it, yeah, could I potentially file it in those countries? And we're all trademark experts, so it's just a little, visual extracted from the WIPO website. But we all know that the more fanciful the trademark, the better in terms of protection. So then that remains a choice. But yeah, here the tool is helping you analyze. Sometimes, once again, you may know it, but you need to report it externally, and you use the tool to provide the draft very quickly. So that's also it. It were some examples of it. We have a second poll for you, and that it would be on which AI, large language models, you're using for your trademark related workflows. Yeah, we allowed either the free version. We wrote ChatGPT copilots from Microsoft. Of course, there are all other maybe more specialist tools, or we know some of our users are using also Perplexity internally. Claude also, especially in France, some are using Claude. So we put them all together. I'd rather to see if it was the free version, the paid version, or internally developed. Yeah, there's quite a big amount of internal version developed in-house. So of course, what can be nice when you are developing something in-house, if it is really internally developed and not just I'm using ChatGPT and I'm providing my documents in an internal developed interface, which is different. But if it is really the LLM you develop in-house, what's nice is part when you are developing something sometimes in-house. So of course that's nice. On this regard, it's easy to get something outdated very quickly. That's why also we don't do fine-tuning here in Qtina, because whatever you did, if you need to redo after some time or change the model, it's lost. You're not scaling up on it. So there are different to see a lot of clients coming back to us saying we wanted to, we spent a lot of time and we are letting down. But that's sometimes it's more also because you need the security. So keep in mind in these situations, not with all systems, but with a system like Qtina, you keep the security part, because really by agreement we have this privacy part, and that's interesting. Thank you for the answers. So let's go on with our examples. And now we switch to the drafting workflows examples. Here it's drafting of goods and services example. In this case, I provided a search report extracted from our search tool, and it's a report made on Sony trademarks. I provided trademarks from different trademarks of Sony, but then I asked I was speaking about ChatGPT. I asked Qtina to draft goods and services that are for a trademark that would be similar to the Bravia one, because a lot of the Bravia brand was included in my report. So it was able to find the different pieces and build a list that was kind of similar to Bravia. And here are many points to make. First, a lot of our users are, of course, asking, is it compliant with the different rules of the pre-approved words, the USPTO, EU IPO, etc.? Our answer, at least for Qtina, is not as of today, but very soon for the USPTO, and to be followed by the EU IPO. And that's why, because we want to make sure that Qtina is drafting something that is really coherent, and that you are not rejected. When filing at the PTO, we are asking to load a list of pre-registered trademarks in the system. The logic would be, if you're a firm, your client's previous trademarks, that is really nice. And if you are a corporate, your own previous trademarks, that would be kind of similar. Of course, you can work also with really similar domains, trademarks that would work in the jurisdiction of interest, and only registered ones. We all understand why. And soon what we will do is be able to grab directly those pre-approved words. And we know it's something that is needed not only, but especially in the US, because they added a fee this year. If you are above, I think it's 1,000 characters and not using the exact pre-approved words, then potentially that's okay. High chances that's okay, but you will pay an additional fee. That, of course, you don't always wish to pay unless you wish to use specific vocabulary. If your client or yourself wish to use some specific vocabulary, you feed it into Qtina. You give it to Qtina. You give it as a prompt. Please, this is what I want you to use, or change this word for that word, or whatever. It's your bot. You chat with it. So you refine the results. So for the moment, we really ask to load this pre-registered list of trademarks in the system. And soon, over time, we will be able to skip, not for all PTOs worldwide. So we focus on what is requested most to us. So that's also why we insist on, please send your feedback. Tell us what you think is needed, what you expect from this kind of tool, and we can work on it. Something that we are going to add also really soon is the possibility to load context, because the document here is the context you provide, to load context from a URL page. Clearly, why? Because all trademark owners have been requesting, and firms especially, because you have to change topics all the time, Ariana. So you are not like the corporate who sometimes know by heart, they're sometimes know by heart their products, at least for some jurisdictions. You need to change and jump from one to the other. So it's reusing the content of a web page to ask to get goods and services that would be in line with the product that is being described or what the company is doing. So this is something we are adding also to have these kind of nice in context descriptions. I don't know if you want to not sitting on this year.
Yeah. Well, really banally, if I have to make an example, we have a fashion company as a client, and of course, they file normally trademarks in class 18, 25, etc., always with the same list of goods, which has been kind of approved in the course of the year. And one day they asked me to prepare a list of goods of products in those classes and other classes connected to merchandise products. So we were a bit outside the normal field. And the issue was, how do I find the goods which may be used as merchandise, for example? So I asked the tool to give me some examples, and actually I fed it with with some of the registrations, and he extracted some ideas of items I could put of goods related to the fashion field, but especially for merchandising purposes. And this is really helpful, because otherwise it would have taken me ages to just go through all the lists and maybe check, Google, etc. But this is super useful because it gives you the possibility of cutting the time extremely.
Yeah, and it's also there to give you some hint. Maybe if you are requesting some specific classes, and it could say, hey, for the product you are targeting, maybe you should add what we tend to miss, the services. Services for those goods. So it will also try and guide you. And I think there are some here, so that's just to show you a little bit the kind of reply you get, where here I said, okay, I also need this ground to apply for cameras. So it has revised the class 9, and it has put in bold what was added, so I can see it clearly. And last step, we spoke before already about translation. I can't judge Japanese, but just to show, you can then say, hey, please now translate in this language. And you can ask someone to review, but at least you have it ready. So it's the goods and services. It's a never-ending topic and an interesting one to work on. It involves a lot of our teams internally to
Absolutely.
look at. Yeah. The substantive office action reply. So here it's a real life example. It's the trademark by GPT by OpenAI. It was stuck at a maybe it's still, I didn't check those days, but it was very recently stuck at the USPTO, because GPT is an acronym. It has a meaning, and maybe using Qthena for the registrability check, maybe Qthena, and that's for sure, would have said, and try and find another trademark, because it means generative pre-trained transformers. And this is exactly what OpenAI is trying to protect for their goods and services. So they were stuck at the USPTO, and funnily enough, it was registered in the EU and in other countries. So when presented that to our clients, I was always saying, "Oh yeah, but it's registered in the EU. It's stuck at the USPTO," and maybe a lot of you have seen that since then it has been cancelled. Well, at least it is being cancelled, and they will appeal. So this is because it's too descriptive. Yeah, that's the problem with acronyms. So here, this is just to show that in this example, we loaded the office action in the system and very lazily asked to reply. And when we are very lazy like that and we just say we need to reply, first it will always do a summary of the office action. Then it will do the part that I extracted. Of course, I need to extract because it's big content. It does a very quick analysis of the grounds for this refusal. And then it will do an expanded analysis of the grounds, and then it will start giving you the possible strategies. When you will opt for your strategy, you will ask, okay, draft the letter based on my choice. So this is same logic as we applied before. And here it says, of course, you could appeal to TTAB because we were in the US, abandon and rebrand, etc. Then if we go further, it will say, oh, likely GPT will now start to defend themselves by claiming the acquired distinctiveness. So this is also what is good. You have a bot in your hands. It means it has no bias. You can ask it both, and I would always advise to do it, to provide you the arguments to go where you need to go, but also provide you the counter arguments that will have the opposing party. So you try to really be ready. So that's also.
And it's really useful also just if you need to do a first assessment to inform the client, for example, that you received an office action and you don't want or don't have the time to contact the local agent. You can ask Cutina to give you the first examination of the provisional refusal based on the local the trademark law, and then you can already give some information to the client, because of course maybe lots of us have experience before the USPTO or the UIPO, so we more or less know the approach. But what about other jurisdictions? So if I have to, for example, examine a refusal in the Philippines and I have no time and have no clue, this is gonna be really helpful to give the client a first idea of what happens next.
And that's it. And then there's the structure of the reply also. Because here, when in Cutina, the skills are, at least on the trademark side, we have for the moment two refinements. One is a refinement for the EU IPO, the other a refinement for the USPTO. It means if when you use the US skill, it really replies with the structure expected by USPTO. Same for the EU IPO. If you want to use it, that's why I was speaking about templates before. If you want to use it for another jurisdiction, of course, please do. Just keep in mind, we improved the structure of the reply for a specific jurisdiction. So whatever element you have in your hands, if you have the structure of a reply, an example one you are using, usually give it to Cutina, give it as a template, tell it to respect this structure, and it will replace its original one you provided. But otherwise, it will use the structure that is expected for USPTO or EU IPO. So that's also for this part of things that can be interesting. The opposition, cancellation, submissions examples now. Here we have a fictive scenario. In our watch system, I set up a watch on Lego trademark and found a trademark that is called Lego Toys, covering same goods, like class 28, really same goods, and provided a such report from the Lego trademarks. Ask Cutina on the basis of which trademark we could oppose the Lego Toys. What's calculate the risk, because, or the chances rather. But that's the same as risk assessment at watch stage, for enforcement. So I think by now you should really have understood the logic of the system and how you can expect to get those replies. Here it says that the strength and fame of the Lego mark already is, of course, playing a very big, given a very big advantage to Lego in this case, and drafting the reason. So then you can ask to draft the opposition. I don't think I have it in the example, but same principle as we saw before. Ariana, I'm voluntarily skipping a bit more quickly because I see we already spoke a lot. It's already 4:80. I try to keep a bit of time for the Q&A. If ever we don't have time for the Q&A, sorry, but no worries. We can always take your questions and answer later, You will receive also the recording, the slides, as usual. So here it was a real life case. when I knew that this was cancelled, I played with Justina and asking, for me, it's a play because I'm not using it, professionally. I'm playing with it. For you that would be using it. So here I'm requesting cancellation of the GPT trademark by OpenAI. And I said, I want to request cancellation for GPT, but also all its variations, GPT-3, GPT-5. Can you analyze, number one, analyze the chances of success. Two, draft the cancellation request. Three, also provide counter arguments. And it's a bit a way to show that the more you structure your questions, what we call a prompt, the best it is. And also it will really reply in this structured way. And you can save your prompts. So if you have to repeat all the time the same thing to the system, it means you should save this prompt. And whatever is the part that is modified each time can be kept out, but save whatever you are doing several times. And here the chances of success were primarily depend on proving that the mark is descriptive of the goods and services, of course, blah, blah, blah. And it's able to cite the article of the UTMR here, which I would not have been able to cite personally. But it cites the article, and that's also the important part on the IP savvy. So I like to insist on the fact that it's really pre-prompted. The meaning of the acronym, what it means, it's not secret or obscure term, at least for the people who file trademarks in this domain. And that's the goal, that it should not be descripted there. And then, of course, calculating the chances of success. Here it said moderate to high, outcome not guaranteed. Of course, we will never say it is. Main challenge will be overcoming the likely difference of acquired distinctiveness, because now it's been used for a while. Of course, the answer would have been totally different 1 year ago, 2 years ago. So that's the game. And this is just a summary of the case for those of you who will read the slides afterwards, if you want to educate someone internally. Also, because I often think that Kitty and I should be the first trainer for juniors to not miss the important parts. I'm not saying it cannot serve seniors. I'm not at all saying that, because I think everyone gains time for sure. But junior, they would even gain in knowledge, I think.
Sure, it can be a guide also to see some determined arguments that maybe you don't always see during your practice. So it can be really interesting.
And that's our last point. It will be really quick. It's just to show a little bit how we decided. So maybe to connect the IPMS with Qtina. That's what we thought was needed. That's what made sense. Why? Because in your IPMS, you're taking care of everything once, at least minimum once it is filed, once you have the asset, not always before filing, or depends really on our clients. But we connected Qtina to the IPMS because once you decide to file, okay, now I need to draft my goods and services. So what we do is that in the IPMS, once you have provided what we call an API key, it's what allows two systems to communicate. Once you have connected your two accounts, then you can create a Qtina project from Equinox. And from Qtina, you can say import documents from Equinox by typing the case reference, and it will load the documents that Qtina can read. Those documents are PDFs and very soon Words. It's not all formats. So it's really a short explanation of that. And we have our last poll. During the poll, I'm very sorry, I will have to disappear 1 second in terms of sound and image, but coming back very soon. The question was, for you, is the connection to the IPMS a big plus? And why did we ask this question? Because all in all, these choices of interconnections are not the easiest ones from a provider point of view. It's we try to do what we think is best, but it's more difficult to assess than what use cases should we work on. This is easy to assess. So here we see that there's 47% yes, great. So you are validating our choices, and not really for some of you, do not know for others. Yeah, okay. No, this is nice. And our last, I think, slides are on the upcoming integration with Markify. So what we want to do is to use Markify API that we already use. For those of you who know IPMS solutions, we do update suggestions on the IPMS content based on what is in Markify, which is our search and watch tool. So worldwide coverage, obviously. But we can do a lot through the APIs. And one thing is to import also information. So we use what we call the data import API to load information of it on a pre-existing trademark. And that's really useful for the risk assessment part. Because if you want to compare the trademark you would need to file for yourself or your client with some pre-existing trademark, then great to not have to download a document, upload the document, you see. So in this case, that's really nice to be able to use Markify API and load this information. So it's gain time and it avoids typos in the copy pasting sometimes. And here what you get is just an example of integration of via the Markify API in another system that we have that is called Brand Proposal. It's a pre-filing workflow system, Brand Proposal. And at the search stage, we give access to the Markify API to do some very brief knockout. Only the knockouts, because if you want to search completely, you really need the full search platform. But that's an example of how you can load results. And that's the same thing that we aim at doing in Qthina to make it easier to compare trademarks. And we can do more. So we are always assessing. We have to choose also, at least the priorities. And this slide is to show the internal flows and how we use, what do we use where. So in blue, you see the existing API connections that we have. It means, once again, that the tools are, do you see the image correctly, Ariana? Because it's...
Yes, I see it.
Okay.
I see it, yes.
Perfect, okay. Okay, so here in blue, in Brand Proposal, we use Markify API to load information. In Equinox, so we have two different Equinox systems. So in one, we are already importing, in the other, we will import very soon. And we use mostly the API to do update suggestion, to check the differences between what is in the public registry, what is in the IPMS. In Equinox, we also interconnect with Brand Proposal because it's a pre-filing workflow. On the other hand, it's the IPMS. So if you want to keep track of all your search project and also keep track of everything that was abandoned, but you don't want to get all that in your IPMS, that's a nice way to combine the systems. And Qthina, the one we have seen today, is also connected with Equinox. The one that is upcoming as to the API connection is what I was citing, Markify in Qthina, at least loading some trademark results. I know that was a lot of content, so I hope it was useful to see some real life examples. It was really great to have you with us, Ariana, also today. I'm gonna check there any questions in the chat.
I see a couple of questions.
I have a problem with my screen. It seems I can't. I don't manage to hide. Okay, maybe. I don't know why I don't manage to access. I had to switch screens at some point, and I don't manage to access the chat. Maybe through here. Okay, great. I managed. So someone asked if we would share the slides. We said yes. Then there was a question, do you know any foreign PTO using Copilot for trademark examination or other private tools for that matter? Great presentation. Thank you for the great presentation. For trademark examination, yes, we know that some PTOs use some tools. It's a bit wide because really some tools like Qtina, I'm not sure. I guess yes, but I'm not sure. Even Qtina maybe on the patent side, because I'm on the trademark side and those skills are recent. Maybe on the patent side it is used by some PTOs and I don't know. What I know is that we are presenting a lot of our different systems to many PTOs and many are clients. Not only Qtina, I mean. As for Qtina, yes, trademark skills are recent. So on this regards for our own tool, I don't think I can answer. Maybe on the patent side, not yet on the trademark side, but that is for sure open. Because for us, PTOs are clients like any other, you know.
Yeah, maybe I can answer to the one regarding the best way to enforce infringement. If I understand the question correctly, actually, what we can do when we have to face enforce infringement, if we have to act against an infringer, I would ask Qtina, maybe with the support, of course, uploading some documents and information, to provide me with some strategies, with some ideas that I can use to argue the infringement. Vice versa, if I had to defend, I would try to claim, for example, to ask Qtina to provide me a draft reply and claiming the legitimate use and registration of my mark. I think that what we can do with this kind of tools is really playing a lot and using them for suggesting strategies, information, analyzing documents, and all in all together, they will give us a very useful output on which we can rely and further analyze and use.
And I think, Ariana, we answered the questions. I have also, what is the cost model of Qtina? Maybe that's the little bit of the question I did not see before. So the cost model is a per user basis. So really the best is to really ask your what we call key accounts manager at Questel, and they can provide you if you want a very quick estimate. You just need to know how many persons you think would be using the system, how many on the patent side, how many on the trademark side. You give this information and they can provide you an estimate very easily. That's the basis of it. Quite simple. So thanks again, Ariana, for the time with us, and we free you to take care of.
Thanks a lot. It was my pleasure, and it's always very interesting to discuss about this topic. So thanks also to all the people who attended, and we took a lot of time of their time. So thanks for the patience as well.
Goodbye. We'll see you soon.
Bye.